do they, is he going to be remotely involved in this hearing today?
He should be here today, yes.
Okay, all right. That'd be good.
Okay.
And when you say be here, you mean in Fulton County Jail?
I can't speak for what the jail's arrangement is, but either in Fulton County or coming via Zoom from Cobb County, one or the other.
Oh, okay.
Okay.
I didn't know that Cobb cooperated like that.
And again, I'm not sure which. That would be up to the jail, but I know that they have
Okay,
people come over from the other jail.
I got you. In any case, I filed the paperwork for a plea in absentia if for some reason there's some issue with him being in attendance.
Understood. Given that this is broadcast on YouTube, you may want to communicate with me offline or via chat. It just may be more straightforward, but I can send you my number if you would like to communicate via phone.
Okay. Uh, you mean your cell number? Your cell?
That is correct. I can put it in the chat for you.
Okay. Yeah. All right.
All right. Robert Webb, I'm not sure, but your video is upside down.
Yeah, I'm aware.
Okay,
I
just
don't
thought
know
I'd
what to
let you
do.
know. Okay,
No.
all right. Okay, good morning, ladies and gentlemen. My name is Judge Lal, and this is going to be the state all-purpose calendar for today, February 13th, 2024. This is a 9 a.m. calendar involving a list of misdemeanor cases in which individuals have already been accused, bonds have been set, and most of the defendants have or should have either an defense attorney who's appointed or retained. Today, we're going to get a status of these cases to see how we're going to proceed with these cases which have already been accused. So if you are a defendant charged with one or more misdemeanor offense, please remember the following. You have a right to remain silent. Anything you choose to say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, courtroom 2. Ms. Vigiletti, good morning.
Good morning, Judge.
Are you still in the middle of interviews right now?
So this gentleman, this is Mr. Dixon, and I have just finished our interview. Most clients are not here in the courtroom yet. And so we do have a lot of interviews to get through today because, you know, 2/3 of the clients were not able to be located yesterday, but
Okay.
for this moment, our interview is complete.
All right, so I'm going to get back to you, but as you need time to address individual clients, just let me know. And I'm going to trust the officers to bring them in as soon as they are determined where they are, or they can Zoom in and we can put you in a breakout session if they're in different locations at the jail facility.
Okay.
In the meantime, I'm going to move on to ACDC. If you could mute courtroom 2, please. And ACDC, Deputy Milton, good morning.
Good morning, Your Honor.
Okay.
Before you is position 23, Byron Shinholster.
Okay.
Judge Byron is somebody that was not able to be located yesterday.
Okay.
I will need to speak with him.
All right. Is there anyone in that room with whom you've spoken?
Yes, Mr. Dixon, who's sitting right here with me.
Okay. And anyone in ACDC with the 3 ladies speaking seated there? Have you spoken to them?
Yes, I've spoken with Tam Pham.
Come forward.
Okay. And the other 2?
And I have spoken with Melissa Stills.
Okay. And
And
who's
I-
the 3rd person, Deputy Milton?
I have
Is-
spoken with Gabriela Gutierrez as well. Yes.
Okay, what about Miss Purdue?
Purdue is a conflict case, and so Ms. Purdue should have a conflict attorney.
Okay, Melissa Stills, are you, give me a few, let me check to see if she's over here. I'm not sure. She might be at Rice Street.
No, well, she was there as of last night. I just talked to her last night at ACB.
You remember what room she was in?
Let me look it up for you. I have it.
Okay, if it's possible, we can do these 3, then I'll take everybody back and go and bring her.
Okay.
Melissa Stills is 7 Southeast, room 206.
Your Honor, I have an announcement at your convenience.
Go ahead.
On the add-on calendar, Mr. Vestra Siebert, we put him on today's calendar just to see if we could work out something with the state with PAD, but we have him already scheduled for Thursday's misdemeanor mental health court, so we're asking just to reset it till Thursday.
Position 3, is just that one case?
Yes, Your Honor.
Okay, so that's reset to February 15th at 11
Correct.
a.m.
Yes, Your Honor.
Okay, got it. All right, Mr. Dixon, I'll be with you shortly.
Maybe excuse me, my only business.
Yeah.
Thank you.
And, all right, courtroom 2, let's see now. This is Ms. Tam Pham, position 22 on the calendar. Charged with 2 counts of simple assault, 23 CR 7607J. And Ms. Pham, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. How are we proceeding, Ms. Vigiletti?
Ms. Pham actually did waive her presence and arraignment today and would like to enter a not guilty plea.
All right. Please submit your waiver of arraignment.
Yes, I did yesterday.
All right, and this is going to be a not guilty plea. Ms. Pham, your case is going to be scheduled for a jury trial, and you will get notice as to when your trial will be set. Thank you. You're free to go. The next person seated behind there, can you come forward?
Come on, Ms. Gutierrez. Yes, ma'am.
Is that Ms. Gutierrez?
Yes, ma'am.
All right, Ms. Gutierrez is position 14, charged with battery, family violence, 24 CR 481B. Ms. Gutierrez, you've been advised of your right to remain silent. Your attorney is Ms. Vigiletti. Ms. Vigiletti, how are we proceeding?
Yes, Judge, Ms. Gutierrez would like to accept the state's recommendation. So we just asked the court to accept the recommendation of the state today.
All right, Ms. Gutierrez, please raise your right hand. Do you solemnly, Ms. Gutierrez? Yeah. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation?
Good morning, Your Honor. It's actually going to be me, Christine Kim, for the state.
All right, welcome, Ms. Kim. All right, and what's the recommendation for Ms. Gutierrez?
Yes, Your Honor. The state's recommendation is 12 months, served 44 days, credit for time served 22 days, balance probated, an alcohol drug evaluation treatment, take an anger awareness class, 40 hours of community service, no violent contact with Amelia Carter, and no alcohol, drugs, and weapons. The state would ask the defense to stipulate ID, venue, and factual basis for the purposes of this plea.
Yes, ma'am.
We do.
And we would,
I'm just sorry, Ms. Kim, it was an alcohol and drug evaluation and anger awareness class. Is that a one-day anger awareness class?
Yes, ma'am.
No,
I
I'm
don't
asking Ms. Kim.
believe so, Your Honor.
What are you all asking for in terms of the anger management program?
1 second, Your Honor. I believe it's an 8-week class.
Yes, yes.
8-week anger management class. Okay. All right. And Ms. Vigiletti, are those the terms to which your clients agree?
They are, and just since Ms. Gutierrez is virtual, I just want to clarify for her, when they say serve 44 days, credit for time served 22 days, that means time served, okay?
Yeah.
Okay, just want to make sure you understand.
Mm-hmm.
And Your Honor, we would ask to sound for the victim, Amelia Carter.
Amelia Carter, if you're present, please unmute and start your video.
Thank you, Your Honor.
All right, Ms. Gutierrez, Ms. Vigiletti, you've also stipulated factual basis, venue, and ID, correct?
Yes, ma'am.
Yes,
All right.
ma'am.
Ms. Gutierrez, have you drunk any alcohol or consumed any medication recently?
No, ma'am. No, ma'am.
And all right, and have you understood what's going on so far?
Mm-mm.
You have not understood what's going on?
I have been sober. Mm.
I know.
Ms. Gutierrez, the judge is asking if if you understand this court proceeding today. Do you understand?
Yes, I do. I do. I do understand it.
Are you okay, ma'am?
Yes, I am okay. I have epilepsy.
Oh, do you need to take a minute?
No, I'm okay. I'm
Okay.
fine.
Okay.
All right. Ms. Gutierrez, are you satisfied with your attorney?
Yes, I am.
And do you understand that if you decide to enter this guilty plea, that you would have to give up your constitutional right to a trial? You will not have a trial in front of a judge or a jury. You will not be able to have the assistance of an attorney to go to court, confront your accuser, challenge the witnesses and evidence brought against you, present any defenses and arguments that you wish to do so, and also give up your right to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
You have to answer out loud, Ms. Gutierrez.
Yes.
Okay.
How do you plead to one count of battery, family violence against Amelia Carter? How do you plead?
Ms. Gutierrez?
Gutierrez, I don't know if you understand what's going on.
Judge, Ms. Gutierrez does have a brain injury that causes medical issues. She was.
Yes,
here
I do.
today. I am wondering if something medical is happening this morning.
Deputy Milton?
Yes, Your Honor.
I don't think Ms. Gutierrez is able to understand the proceedings. Can you give her a few minutes to rest and I'll get back to her?
Okay. And I have Melissa Stills here. Have a
Okay.
seat, sweetheart, have a seat right there for me, Ms. Gutierrez. Yeah. Come on, Ms. Stills.
This is Miss Hill?
Ms. Stills, Melissa Stills, position
Yes, okay.
24.
Okay. And what are we doing there, Ms. Vigilante?
Ms. Stills would like to accept the recommendation of the state, so we just ask the court to accept that recommendation this morning.
Miss Melissa Stills is case 21 CR 003697J. Ms. Stills was accused of public drunkenness from January 26, 2020. Ms. Stills, my name is Judge Lal. I want to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigilante. Do you see Ms. Vigilante on the screen?
Yeah, ma'am.
All right. Could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Kim, what is the recommendation for Ms. Stills? You may put your hand down, Ms. Stills.
Thank you, Your Honor. The state's recommendation is serve 15 days, credit for time served 15 days. And the state would ask the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
We do.
Ms. Stills, have you consumed any medication or alcohol?
No, no, ma'am.
And have you understood what's going on?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And if you decide to plead guilty to this charge, you understand that you will not have a trial in the future. You have to give up your right to go before a judge or a jury for a trial, to confront your accuser, to challenge the evidence brought against you, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am.
Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of public drunkenness?
Guilty.
Your sentence is 15 days. You've served the 15 days. It's concluded. You're free to go. Thank you.
Ms. Stills, I did want to tell you, I did talk to your daughter, okay?
Okay.
Okay. Take
Thank
care.
you. Love you.
Thank you.
That's a Yelp review for Ms. Vigilante.
Yeah.
Deputy Milton, anyone else who's ready?
Okay, the only two left is Purdue and
Gutierrez.
Shinholster and Gutierrez.
Are those the two, Shinholster and Gutierrez?
Yeah, Shinholster and Purdue are real position 20 and 21.
Okay. Is one of them the conflict counsel?
Purdue is the conflict case.
Okay. And Byron Shinholster, you've got to talk to him, correct?
Right.
All right. And Deputy Milton, I'll get back to Ms. Gutierrez as soon as I'm finished with Mr. Dixon. Hopefully she's feeling a little better. All right?
Okay.
Mute your screen. Mr. Dixon, this is William Dixon in courtroom 2. Mr. Dixon, you've been advised of your right to remain silent. Your attorney is Ms. Vigilante. She's addressing your case 23 CR 6830C, in which you've been accused of criminal trespass, public drunk, fare evasion, and simple assault. How are you proceeding, Ms. Vigilante?
Judge, Mr. Dixon would like to accept the plea, but did have a question for the court about time served this morning.
All right. I guess we will proceed with what is the recommendation, Ms. Kim, for Mr. Dixon?
Yes, Your Honor. The state's recommendation is to serve 30 days credit for time served since February 5th of this year.
So he's been in custody for 8 days
Yes. Yes, Your Honor.
and the balance suspended?
Yes.
All right. So according to this, I believe he has 7 more days to serve.
Yes, Judge, and Mr. Dixon was arrested in East Point on February 1st and just wanted to ask the court this morning if you would be willing to consider those additional 4 days. He was arrested in East Point. They ran his background and discovered this warrant. So all did come to Fulton County on the 4th, the 5th, I believe. He has been in custody since the 1st.
All right. Any objection to giving him credit for 13 days?
Yes, Your Honor.
What's the objection?
The plea was to serve the 30 days credit for time served February 5th, and he wasn't in custody for East Point for this case. We would ask that the judge follow the recommendation as.
Was he transferred from East Point to Fulton County?
State is unclear at this moment.
All right. I'll give him credit for 13 days, but he has to stay away from all Marta property for 30 days.
Understood, Judge. Thank you.
Or, yeah. I'm assuming he doesn't have a suspension, so.
Yeah, he does have a ban, but it is temporary, and so 30 days he can comply with both at the same time. Thank you.
All right. Does he want to proceed with the plea?
Yes, Judge, thank you.
So he'll have to serve 1 more day in jail. Does he understand that? It's either 1 or 2. My math may not be the same as Sheriff Labat's, so it may be 1 or 2 extra days.
Understood, Judge. Thank you.
All right, Mr. Dixon, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do.
And Ms. Kim has already allocated the terms. Do you stipulate to the factual basis, venue, and ID for all 4 charges, Ms. Vigiletti?
We do.
All right. Mr. Dixon, have you consumed, you can put your hand down, sir. Have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, I am.
Are you satisfied with your attorney?
I am.
And is anyone forcing you to take a plea offer today?
Yes.
Is anyone forcing you to take a plea offer today?
No, ma'am. No, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not be able to face a judge or a jury. You will not be able to have the assistance of counsel to confront your accuser, challenge the witnesses and evidence brought against you, present your own defenses, and have the state try carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
I am.
How do you plead to 1 count of criminal trespass, public drunk, fare evasion, and simple assault?
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 13 days. You have additional, I believe, 2 more days to serve at the Fulton County Jail. The balance will be suspended. I'm going to require you to stay away from all Marta property in accordance for an additional 30 days, which is going to be added on to whatever suspension you've got at the present time. Do you understand?
I do.
So if you've got a 1-year suspension, it's going to be 1 year and 30 days.
Understood.
All right. Ms. Vigiletti, we've got quite a few folks who've joined you in courtroom 2.
We do.
If you pan the crowd, you need to speak with all of them?
Judge, if it's possible, perhaps Mr. McLean is here now, so perhaps
All right, excellent. Thank you. Good morning, Mr. McLean. Okay.
Good morning.
And do you need to speak with all of them presently?
I have a couple that are ready and a couple I need to speak to. It's just a matter of who's in the courtroom.
All right.
When I say a couple, I think there are 5 that were missing and some 2 guests last night.
Well, let's address the ones that you have in the courtroom right now, and we'll take the others as they come in, okay?
We'll figure out who we've got here. Thank you.
Sounds good. And Ms. Vigiletti, let's address Miss Gutierrez. Ms. Gutierrez? Deputy Milton, are you at ACDC?
I'm sorry. Thank you.
And Your Honor, whenever you're ready, I have position 1 from Cobb County, Mr. Beatty. I believe he has a private attorney.
Okay. Deputy Milton at ACDC?
I don't even know back. I don't know how to 18 months. I don't remember. I don't know how to.
Mr. Bartels thought that this case would be in the public defender office.
Deputy Milton, I was just going to address Ms. Gutierrez, if she's feeling better.
Yes, ma'am.
All right. Ms. Gutierrez, I'm going to continue with the plea hearing. Can you hear me all right?
Yes, ma'am.
All right. As I was saying, if you decide to plead guilty to battery, family violence, you would have to give up your constitutional right to a trial. You will not be able to face your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charge of battery against you beyond a reasonable doubt. Are
Yes.
you prepared to give up these rights?
Yes.
All right. How do you plead to 1 count of battery, family violence?
Yes.
Listen very carefully again. How do you plead to 1 count of battery, family violence? Do you plead guilty or not guilty?
Guilty.
Your sentence is going to be 12 months to serve 44 days, credit for time served 22 days. That means your jail time is finished. Do you understand?
Yes.
You will report to probation next week at 132 Mitchell Street in downtown Atlanta.
Yes.
Understand?
Yes.
Your report date is next Tuesday, which is going to be February 20th, and you must report before 3 p.m.
Yes.
While you're on probation, you will complete an alcohol and drug evaluation.
Yes, I understand.
Okay. You will complete 8 anger management classes.
Yes, I understand.
You will complete 40 hours of community service.
Yes, I understand.
And you cannot have any violent contact with Amelia Carter.
I I understand.
All right.
I understand.
That is going to be your sentence. Please don't forget to report to probation next Tuesday.
Yes, I understand.
I'm so glad. Good luck. Thank you. All right. Deputy Milton, I believe Miss Vigiletti is going to have to speak to Mr. Brian.
Yes, if she has her cell phone, she can call over here.
All right. Can you put the phone number in the chat to courtroom 2?
I don't have a phone, but could I log into the Zoom and could we do a breakout room?
Okay,
Okay,
perfect.
I will log on in just a second.
All right.
Okay.
Where is the individual from Cobb County?
Mr. Mike McLean is actually talking with him right now, Your Honor.
Oh, okay.
So
You wanna, let me know when the conflict attorney comes on for Miss Purdue.
All right. Are there any other private attorneys on the Zoom? Private defense attorneys on Zoom?
Mr. Webb should be present. I don't know if you've already acknowledged him.
I did. Mr. Webb, who's your client? Mr. Webb, please unmute. Who is your client?
John Webb, he's was added on.
John Webb.
Yes.
Quite a few add-ons.
Yes, he is the most recent add-on calendar, Your Honor, and it is
I
on
don't
that
have
most.
the add-on calendar.
Oh, he's position 6 on the most recent add-on, and I can send that over to the jail.
Hey, get one with a 6th position on it, I don't believe.
I don't think, Ms. Vigiletti got that recent add-on either.
Yeah, Judge, I will say the add-on calendar I have has 5 positions on it.
And the most recent add-on calendar has 7.
It was sent out yesterday afternoon, everyone.
All right,
But
yeah,
Mr. Webb was aware of his client's presence and has signed the form as a plea, had his client sign the form as a plea in absentia in case he cannot be brought over.
I have them. I'll go get them.
Thank you.
All right, just give me, about 10 minutes.
And could I be put in a breakout room in the meantime with ACDC?
yes. Miss, let me see who is hosting today.
Miss Champion, Judge.
Miss Champion, there you are. Okay.
Now.
All right, Miss Champion, if we could place the Zoom panel, Olivia Vigiletti and Deputy Milton.
I'm right here, Your Honor.
All right, ACDC is going to go into a breakout also. There's going to be a message on the screen to go into a breakout room. Ms. Vigiletti, please watch your screen. You're going to get a message to join a breakout. All right. Mr. McLean, are we ready to address whomever you'd like to address?
All right. Lewis Wright is a plea, but I don't think he's in here. Is he on screen anywhere?
No. Everyone's in your room.
I also have a couple of arraignments where we can waive the reading of the accusation
All
and
right.
on request.
Go ahead and tell me which one.
That's going to be, let's see. Easton Clark, Your Honor, is a not guilty, but bond is moot, so he's.
I'm sorry, I didn't catch the last name. Could you give me the last name?
Yes, Your Honor. Easton Clark is here,
Okay, position 6 on the SAP calendar.
and that's not a bond request. It's just a not guilty, and I'm going to waive the formal reading of the accusation. And in fact, is Clark in here? Okay, Clark's not in here yet, so I'm going to ask him if I can waive his presence as well. We did talk yesterday. Is Marcel Jones in the courtroom?
Are you filing a waiver of arraignment, Mr. McLean?
Your Honor, I have a blank form with me. I can do that, and I will.
All right, on Easton Clark, position 6, Defense Counsel McLean will file a waiver of arraignment.
And make a note of that, so I'll be sure to get it in with exclamation
you.
points.
And this will be further notice for trial.
Right, Mr. Marcel Jones is in the courtroom, number 17, and he would like to plead guilty, Your Honor.
All right,
That's my understanding.
is that your client or is it Ms.
Yes.
Vigilante? All right,
It's number 17.
all right. And did you have any other waiver of arraignments?
I have a couple, let's see, Mr. Charles Wilson, number 31, is a not guilty, but that's going to be a bond request, so we will be speaking for
Okay,
a short
okay.
time when he sits down.
all right, let's address position 17 on the SAP calendar, State versus Marcel Jones, accused of theft by taking and giving false information to an officer. The accusation number is 24 CR 382A. Mr. Jones, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean.
Okay.
This is going to be a plea matter. Mr. Jones, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. And Ms. Kim, what's the recommendation for Marcel Jones?
Yes, Your Honor. The state's recommendation for the theft by taking will be 12 months, served 58 days, credit for time served 29 days, stay away from Northside Hospital, restitution open for 30 days, and 40 hours of community service. And for the giving false information to law enforcement officers, that's going to be 12 months of probation to run concurrent to count 1.
All right. And Mr. McLean, are those the terms to which your clients agreed?
Those are the terms, Your Honor, and we always consider it not to be outside of the terms or breaking a negotiation for me to ask the court to consider giving him a financial break for 2 months, for example, for for the probation fees so he can get on his feet.
Okay,
And perhaps do non-reporting or termination upon completion of special conditions of probation would be super as well. And
is he
we,
currently employed?
I don't believe so, Your Honor.
All right, give him 2 months probation, suspended fees, for the month of February and March.
And Your Honor, we do stipulate to factual basis, identification and venue for the purposes of the plea, and he does ask the court to accept his negotiated plea.
All
I
right,
have contact information for him. I've already written down, so he's ready to go.
sounds
In
good.
your honor, the state is consenting, or I mean, not objecting to the waiver of probation fees and non-reporting, but we would be objecting to termination.
Okay. All right, Mr. Jones, have you consumed any medicine or alcohol?
No,
And have you understood the proceedings so far?
yes,
Are you satisfied with your attorney?
yes,
And is anyone forcing you or inducing you to take this plea offer today?
no.
Just 1 second, please. ACDC, have you gone into a breakout with Miss Vigiletti? Okay. Mr. Jones, if you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial. You will not be able to go before a judge or a jury. You will not have the assistance of counsel to challenge the evidence brought against you, to confront your accuser, and to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes,
How do you plead to 1 count of theft by taking and 1 count of giving false information to a
No.
law enforcement officer?
guilty.
Your sentence is going to be 12 months to serve 58 days, credit for time served 29 days. If you have no other cases holding you at the jail, you should be released within 24 hours. You will
Appreciate it.
go to probation next Tuesday before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are out on probation, you will complete 40 hours of voluntary community service at any nonprofit agency that's not a church and not a school. Your probation fees will be waived for the month of February and March 2024. This case will remain open for the state to schedule a hearing in order to determine restitution as well. Once Mr. Jones has completed his 40 hours of community service, his probation may be non-reporting. Thank you. Oh, and the sentence for giving false information is concurrent to count 1. Thank you.
Release in 24 hours. Thank you, Judge.
Thank you. I'll take this piece of paper with me.
Take that. That's my.
That's your
Who has position number 7, Clark?
number 7, Clark. We had 3 Clarks.
Keon Clark, position number 7.
Clark? I'm sorry, where is Keon Clark?
He's at medical.
Hi, we haven't met. I tried to come find you yesterday. They couldn't find you.
Yes.
You still need to speak, Judge.
All right. Have you completed your interview with ACDC?
I have, yes.
All right. Medical, if you could hold, please. Miss Vigiletti was going to go into a breakout with Mr. Clark. ACDC, and we're going to deal with Mr. Shinhoster. This is position 23 at ACDC. Mr. Shinhoster, you've been advised of your right to remain silent, and your attorney is Miss Vigiletti. This is 23 CR 5853J, in which Mr. Shinhoster has been charged with theft by shoplifting. Excuse me. How are we proceeding, Ms. Vigiletti?
Judge, Mr. Shinhoster would like to accept the plea as negotiated by the state. So we just asked the court to accept that recommendation this morning.
All right. Sir, could you please raise your right hand? Mr. Shinhoster? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
So, Mr. Shinhoster, I understand that you're willing to consider the plea offer in exchange for a guilty plea. Is that your understanding?
Yes, but I just want to get a clarification on the guilty plea before I submit my rights, if that's okay with you.
I don't know what you're seeking clarification. What exactly do you need clarified?
My clarification is that I'm homeless and I'm seeking I got housing, and I can't receive housing where I'm gonna receive housing with probation. So I can't be on probation at these programs that I'm going into. So I just want to make sure that I'm not on probation, whatever the plea.
Let me see what Ms. Kim says. Ms. Kim? Or Ms. Falk?
Your Honor, the state's recommendation would be time served. He was arrested in November 10 of 2023.
Okay.
We would ask the defense to stipulate to ID, venue, and factual basis for the plea.
We do.
All right. And anybody can give me a ballpark of how long that time was since November?
More than 3 months, Judge.
Y'all need to put something on a disposition.
I believe it's 96 days, Your Honor.
All right. Okay. Mr. Shinhoster, the recommendation is that the time that you've served in custody would be your sentence, and that would close out the case. There would be no additional time to be served on probation. Do you still want to move forward with the plea?
Yes, ma'am, I do.
All right. Ms. Vigilante, do we stipulate to the factual basis, venue, and ID for the theft by shoplifting?
Yes, Judge.
All right. Mr. Shinhoster, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings?
Perfectly.
Are you satisfied with your attorney?
Yes, ma'am.
Is anyone forcing you to take a guilty plea today?
No, ma'am.
And has it been explained to you that if you have 3 or more theft by shoplifting convictions on your record, any subsequent arrest for the same or similar offense will automatically be a felony charge?
Yes, ma'am.
Are you still willing to move forward with the plea?
Yes, I am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial before a judge or jury. You will not be able to confront your accuser, challenge the evidence brought against you, present any defenses or arguments if you choose to do so, and have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of theft by shoplifting?
Guilty.
Your sentence is to serve 96 days, credit for time served 96 days, and that concludes your time, and your, in this case, is closed. Thank you.
Thank you.
Thank you, Judge.
All right, ACDC, I think we are, with the exception of the conflict case, right? Do we have any conflict counsel on Zoom? All right, so we're just waiting on conflict.
Donna, I have, Mr. Webb for the private attorney, if you're ready for
Yes, please. And then, Ms. Vigilante, I'm going to put you in a breakout with medical, please.
Okay.
Okay, you will go back to the same breakout, Ms. Champion.
I know.
Olivia Vigilante will go back into the same breakout. And medical, you will see a message on the screen to join a breakout. Is there a staff member at the medical? Okay, excellent. Ms. Vigilante, please join the breakout room. Thank you. Mr. Robert Webb, is that your client, John Webb?
Yes, it is.
All right. Deputy, thank you so much for bringing Mr. Webb over. This is position 6 on our add-on calendar. State versus John Webb. Mr. Webb is accused of 1 count of misdemeanor battery from September 6, 2023. The case number is 23 CR 6955E. Mr. John Webb, my name is Judge Lal. I'd just like to remind you that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Attorney Robert Webb. Mr. Robert Webb, how are we proceeding in your case?
Your Honor, this is a plea of guilty to the 1 count of battery. The agreed upon sentence.
I just wanted to know whether there was going to be a plea hearing.
Okay, all right.
In that matter, John Webb, please raise your right hand.
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what's the recommendation, please?
Yes, Your Honor. The recommendation is 12 months, serve 131 days. The defendant will receive credit for time served for 131 days from October 5th, 2023. There is no early termination on this case. We are asking for 12 weeks of anger management. He will be doing the anger management classes through MARR, M-A-R-R, Addiction Treatment Center. No further contact with Ms. Corey Anderson, who is here on the Zoom today, and stay away from Emory Hospital. As we stated, Ms. Anderson is present on the Zoom and would like to be, and we would ask if she would like to be heard, and we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Yes, we will stipulate.
All right. Ms. Corey Anderson, good morning. My name is Judge Law. Would you like to contribute to the proceedings?
Since I understand that he's pleading guilty, I don't think that there's anything that I need to add.
All right, thank you very much. Mr. John Webb, have you consumed any medication or alcohol recently?
No, ma'am.
Have you understood the proceedings as they are going on right now?
Yes, ma'am. I just was, yes, I do understand. I was just curious. Can I ask a question real quick?
You can ask the question and I'll decide whether your attorney can address that privately. Go ahead.
Yeah, it's just the question was about the 12 months of probation that I have remaining. It's just that I serve it on probation. Okay, never mind. She's helping me right here to just go on. That's not that we haven't done that yet. Never mind. I would just like to apologize is all.
All right. Mr. Webb, is anyone forcing you or inducing you to plead guilty to this charge?
No.
Okay, listen to me.
Yes.
Don't listen to anybody else. I want to make sure that, okay, and sit back, please, so I can see your face. Thank you.
Yes,
all right.
Yes, ma'am.
Are you satisfied with your legal representation?
Yes.
Has it been explained to you that if you decide to plead guilty to this charge, that it will be a conviction on your record?
Yes, Your Honor.
And has it been explained to you that if you decide to plead guilty, that you will not have an opportunity for a trial in this case? You will have to give up your right to a bench or jury trial. You will have to give up your right to have the assistance of counsel, to go back to court, to confront your accuser, challenge the evidence that's brought before you, have the ability to present your own defenses and arguments if you choose to do so, and also give up your right to have the prosecutor carry his burden to prove the charge against you beyond a reasonable doubt. These are constitutional rights that you would have to give up if you decide to plead guilty today. Are you prepared to give up such rights?
Yes, ma'am.
How do you plead to one count of battery?
Guilty, ma'am.
Your sentence is 12 months to serve 131 days, credit for time served 131 days. The balance of the time will be on probation. I understand that you will be undergoing treatment at MARR.
Yes, ma'am.
Where you will then do your 12 weeks of anger management classes.
Yes, ma'am.
At all times while you're on probation, you're to have no contact with Corey Anderson. You're to stay 200 yards away from her and not communicate with her in any way, form, or manner, directly or indirectly, and even on social media. You have to stay away from all Emory Hospital facilities unless you have a express appointment with a specific healthcare provider or you are seeking emergency treatment. Do you understand?
Yes, ma'am.
All right. Now, speaking of probation, since he is going to be enrolling in MARR, will he be able to report to probation in person?
No, he will not. He will be in residence at MARR for a minimum of 12 weeks, and it can be extended based on the treatment protocols that they have there.
All right. Ms. Falk, do you have any objection to telephonic reporting?
I do not have any objection as long as he is enrolled at MAR. If he leaves for any reason before that 12 weeks, he will need to report in person.
And Mr. Robert Webb, would your client be able to report to probation for the first visit?
The first visit after, you mean before?
It would be next Tuesday before 3 p.m.
No, once, the plan is for him to go straight from his release, which I am hoping will happen today, to the MAR program and enter into the program.
All right, so we have our probation officer, JCS, Ms. Thomas, on the Zoom.
Yes, good morning, Your
Good
Honor.
morning. You would need a phone number from attorney Robert Webb to facilitate telephonic reporting with Mr. John Webb.
Okay, so if we have an email address, because the phone is messing up on our end too, if we have an email address, we can he can report through email.
Okay, Mr. Robert Webb, if you could put down your email address for probation office to communicate with your client, as well as an email address for your client. We do have a few electronic hiccups right now with Fulton County IT. So email would be the easiest way to communicate with your client.
All right, Ms. Thomas, could you give me your?
It's in the chat feature.
It is?
Yeah, it's in the chat. When you click on it, it will have a list of participants. You will click on JCS-Ms. Thomas. You see it?
Yes, I do. Okay.
And,
so that's her email will be provided there?
No, you would type in your email address, and if you have it, your client's email address.
Yeah, he does not have one. He is homeless, and so that brings me to the next question is, can his probation fees be waived if there are any?
I'm going to waive his probation fees for 3 months. Ms. Thomas?
Yes.
He's going to be enrolled in a facility called MAR, M-A-R-R.
Okay.
Mr. Webb, you would need to give the contact information for that facility, location, anything, email, phone number, so that probation can verify with the facility, because they can also communicate with the facility to make sure that John Webb is enrolled in there.
Okay.
If he leaves the facility, he needs to report to probation in person and let them know that he's completed his treatment and that he can resume in-person reporting.
Okay, and that would be at 132 Mitchell Street?
Correct. That's the probation office location, yes.
Yeah, okay. And then once he completes his, can he go non-reporting once he completes the treatment program?
I like him to report.
Okay, it's just I'm not sure what his situation will be at that time and his ability to get transportation. That's all.
Your Honor, the state does object to non-reporting. We would also like him to report given the circumstances.
Yeah. Mr. Webb, your client will have to report. I'm going to waive his probation fees.
All right, John.
All right, thank you.
Thank you. Could I get just some direction? I see he's in courtroom 2. Is that in Fulton County?
That's at Fulton County, the Fulton County Jail at Rice Street in Atlanta, Georgia.
Okay.
And if you need to pick up your client, you would need to go to the front desk and let them know that you're here to pick him up.
At Rice Street. Okay.
At Rice Street. And it takes up to 24 hours to release.
I see. All right. Is there anyone I can contact at Rice Street to find out when he will be released? Rather than just
Deputy Norris, if you just go to the front desk, you should be able.
Here's Deputy Norris.
Yes, Judge, how you doing? I'm
Oh,
here.
fine, thank you.
You need me?
The attorney wants to know whom can he contact to make sure that his client is released so that he can pick him up.
You can call central control, but there's no phones working. We're still,
Oh, that's right.
yeah. So
All right, Mr. Webb, it looks like you have to do an in-person show up.
that is correct.
Right.
It's
Okay.
about 10 o'clock in the morning. If you're there tomorrow at about 8:39, you should be in good stead.
Okay, all right, very good.
Judge
you.
Law, I do have one request to make. Is it to ensure that he actually did attend treatment? We would ask that when he attend probation for the first time after his release, that he provide documentation to probation that he did complete the treatment.
I
All
think we'll be doing telephonic reporting. He's going to be picked up and taken to MAR right away. That's why we need the facilities information with probation.
Okay,
But they will contact and verify his intake.
thank you so much. I appreciate that.
Okay. Moving on to, thank you, Mr. Webb. You're free.
Thank you.
Okay.
Thank you, John.
Thank you.
I'm done.
Excuse me, Your
Mrs.
Honor.
Anderson, thank you very much. You're free to go.
Your Honor,
Yes?
the conflict attorney come on already?
No. What would you like to do? Is this the only case you're on hold for?
Yes, Your Honor.
Okay. I'm going, and this was for,
It's Purdue
Purdue.
for 20 and 21.
Miss Kim or Miss Falk, was there an offer for Purdue positions 20 and 21?
There is, Your Honor.
Is there additional time?
It would include time served, Your Honor.
Okay.
Your Honor, I got in touch with Ms. McLeod. She states that she's in courtroom G33. As soon as she's finished up there, she'll come upstairs and log on.
Oh dear. So she said Orca jury trial calendar call. Okay. Deputy Milton, is there any way that you'll be able to hang on for another half an hour?
Yes, I'm gonna log off and then I'll come back.
Okay, all right, thank you.
You're welcome.
All right, courtroom, Ms. Vigiletti, are we ready to address your client at the medical unit? All right. Mr. McLean, are you ready to address your client from Cobb County?
Your Honor, my client from Cobb County, Mr. Beatty, is an unnegotiated plea, and I also have the person on the calendar right after that, who I believe is, first name is Geraldo, and it starts with a B. That's simply going to be a negotiated plea.
All right, let's do it on Travius Beatty, please.
Both of those people are in the courtroom. Mr. Beatty, if you'll have a seat in the chair.
Don Travius Beatty is case 22 CR 003-459B. Mr. Beatty, you've been advised of your right to remain silent, and your attorney is Mr. Michael McLean. He's charged with a misdemeanor offense of possession of pistol or revolver by a person under the age of 18 from June 1st, 2022. Mr. Beatty, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no.
Yes.
Thank you. All right, Ms. Falk, what's the recommendation for Mr. Beatty?
Your Honor, the state's recommendation for John Travius Beatty is 12 months to serve 210 days in jail. He would receive credit for 39 days. That would be from June 1st, 2022 to July 9th, 2022. Let me just, if I can just have a moment to check to see why he is currently in custody. My odyssey is, the information I'm pulling up is not, is working very slowly. We also would ask that the balance be on probation, that he have no firearms. If Your Honor can give me just a moment, I can provide the a little bit about the history and the facts of this case. So this incident happened back on June 1st, 2022. Mr. Beatty was observed at the location of 921 Westmoreland Circle Northwest in Atlanta, around a stolen car and in possession of a handgun. At the time of this incident, he was 17 years old. The defendant's history is that he has 8 cycles of arrests beginning in 2021. So in 2021, he was arrested for entering auto with intent to commit a theft, identity theft, when using or possessing identifying information, and financial transaction card theft. Another case in 2021, he was arrested for robbery and entering auto. Another case in 2021 for possession of or sale of marijuana. Another case in 2021 for theft by receiving, possession of a firearm or knife during commission of a felony, and possession of a pistol under 18. 2021 theft by taking and entering auto. 2022 failure to appear for theft by taking and entering auto. And then this case in 2022 for possession of a pistol or revolver by a person under the age of 18. So what we're seeing here is, starting in 2021, a very troubling history, including 8 cycles, 7 of which were arrests and for new offenses, and 1 of which was a failure to appear on a previous offense, which gives the state some concern about the trajectory of this defendant's history, which is why we have requested the time served that we have requested on this case.
All right, thank you.
Your Honor, it looks like he's on probation too. He took a plea on December 2023 for a felony case also.
All right.
And my
Thank you.
apologies, Your Honor, we couldn't see that with the issues with the system.
You need the case number?
Yes, that
please.
would be helpful.
22 SC 18202. And it's for, looks like 2 counts of entering auto, possession of tools for commission of a crime, theft by taking, 2 counts of theft by taking, and criminal trespass. He took the plea December 1st of 2023. Looks like he has 4 years probation on that case, and it was 1 year confinement.
All right, so he's still in confinement for that then. He's still got time to serve in that matter. Okay,
I can speak to that, Your Honor.
all right. Anything else, Ms. Falk?
That's all for the state, Your Honor.
All right, Mr. McLean?
Your Honor, while I am unable to check on Odyssey to know my exact math, I believe the situation is pretty much in good faith like this. I explained to him that the state's recommendation would result in, according to those 3 numbers, 66 extra days. He tells me that he is waiting on Georgia Works. He's been accepted, and he's just waiting for a slot on that previous case. So he is anxious, not anxious, eager is a better word, to go to Georgia Works and get on with his life. He has realized that several of these things are negative from his past. He's a young man. The particular incident here, Your Honor, I'm told, I advised him, I said, you know, you could go to trial. I mean, everybody's presumed innocent and proven guilty, and you might want to talk to a jury about this. But he said, well, I'd like to go to Georgia Works right now, and Your Honor, there would be a sufficient factual basis to justify his asking the court to accept his unnegotiated plea for the purposes of the plea. If Your Honor could consider his youth, consider that Georgia Works is waiting on him, he's waiting on Georgia Works, and he'd love to go now. If 39 days is the correct calculation of, and this is where I'm deficient in that I don't have the Odyssey right now. If 39 days is correct, Your Honor, if I would be asking for time served on the jail portion of the sentence, and then allow the probation to start with whatever conditions the court thinks is fair. So 39 times 2 is 78. So what I'm asking the court to consider doing is giving him 12 months probation, 78 days to serve, 39 days credit, balance on probation, no firearms, any other conditions the court thinks would be fair to pile on. He's accepted that guilty plea he was in Cobb jail. I've been in contact with Mr. Bartels of our office. We were trying to see him in Cobb. We were trying to see him here. We
Was
finally,
he in Cobb County because of a Cobb County matter, or was he arrested pursuant to this case?
just Fulton County renting a jail cell. I think that's all that was.
All right. Ms. Falk, any comment about this defense's proposal?
Your Honor, I think the proof is in the pudding here with the defendant's history. Actually, I am seeing he pled on 2 of his cases. So there was the 18-5202, which is entering auto, theft by taking, criminal trespass, and possession of tools. And then he also pled on 22 SC 182228, theft by taking and entering auto. So his history is pretty much riddled with felonies, and now we have him in possession of a firearm under the age of 18 years. I think the jail time is more than sufficient for his history.
All right, thank you.
My point is simply let's make that history and let's move on with the future.
Mr. McLean, on a clear, bright, sunny day, I would definitely agree with you. But this is not a question of what Mr. Dontravius Beatty wants. It is what is fair and reasonable. And Mr. Beatty has a very, very troubled history. And it's a question of whether whatever he wants, he has to earn that. And right now, the way he earns that is paying his debt to society. I am going with the state's recommendation, which is to serve 210 days, credit for time served 39 days. I won't begrudge him the fact that the sheriff's office has a 2-for-1 ratio, which means he has to serve 66 more days at the Fulton County Jail. And then in addition to that, he will report to probation not only for his other outstanding sentences, but also for this particular case as well. He'll be required to report to probation twice a month. I will waive his probation fees for the first 5 months. He is not to possess any weapons or any firearms. And he's also to undertake a firearm safety class and do 80 hours of voluntary community service.
Your Honor, if I may, I'd like to put him in the back corner while I take another plea, and then I'll go back and discuss what was just said to him and see if we're going forward.
Yeah.
That'd be
Thank
great.
you.
Okay. Go in the back corner. I'll take the next bit. Your Honor,
Next case is Geraldo Bartolan.
right. And this is a very simple one, Your Honor. It's just time served, period. No balance.
All right, sir. This is to Geraldo Bartolan, 20 CR 002043E. Mr. Bartolan is accused of loitering and prowling from March 10th, 2020. Mr. Bartolan, you've been advised of your right to remain silent, and your attorney is Mr. Mike McLean. May I place you under oath for purposes of the plea? Mr. Bartol, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right, Ms. Kim, what's the recommendation for Ms. Is it just time served?
Yes, Your Honor. We would ask again the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
For those purposes, we certainly do.
And how much time has he already served?
Your Honor, I'm not seeing an exact date due to our Odyssey being down, but I do see that there was a failure to appear on this case and an arrest in February 3rd of this year, so 10 days, Your Honor.
All right. And Ms. McLeod?
Good morning, Your Honor.
Good morning. Your client's at ACDC. If you want to give them a call, if you yes.
Well, I don't know that I can call them, Your Honor.
Okay.
I don't know a working number for them, but I was wondering if you could do a breakout room so I can speak with Ms. Purdue.
I would have to have ACDC. I think she's signed off right now. She's attending other matters. But I told it'll be another 10 minutes, I think, before
that will be, Your Honor, I'm available.
Okay, if you please hold. Thank you. All right.
You're welcome.
All right. And I'm sorry, Mr. McLean, you've already stipulated the factual basis venue ID. Is there a stay away provision, Ms. Kim?
Not that I see, Your Honor.
Okay. Mr. Bartolan, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings?
Yes, Your Honor.
Is anyone forcing you to take this plea offer today?
No, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor.
If you decide to plead guilty, you would have to give up your constitutional right to a trial. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state carry its burden and prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Right, your sentence is to serve 10 days, credit for time served 10 days, balance suspended, and that closes the case.
Thank you, Your Honor. Thank you.
Thank you.
All right, Ms. Vigiletti?
Yes, Judge. Ms. Fong, I did just send you an email. I'm sorry, Ms. Kim, I don't have your email, but I do believe Keon Clark's case was NOD'd on first appearances on February 6th. And so I do believe it may be a mistake for Keon Clark to be on our calendar today.
What's the first name?
Keon, K-I-O-N-N-E.
Well, Your
What?
Honor, since
Yeah.
I was not present for that, I will need to reach out to Mr. Ian Walker and find out if he is aware of any kind of NOD on that case.
Yeah, and I did just forward you the email from Michael Jordan that case was NOD'd on February 6th.
Okay.
Could you forward that to Ms. Champion or Ms. Casey Strong, please?
Yes, ma'am.
Ms. Strong, please.
Ms. Strong, Ms. Casey Strong. All right, if that case is NOD, then that's not the case holding him at the jail. Would that be correct?
And I mean, of course, with our systems down, I can't be 100% sure, but that seems to be the only case, the only open case for Keon. So I am wondering if it might be a mistake that they're still here.
The date of the incident is August 6th, and this was a bench warrant.
Yes, and so my understanding is that
How would it be NOD'd at first appearance? Unless the bench warrant was set aside.
so I wasn't present. I'm not sure. I got the email. I did also speak with the attorney, Keith, who worked on the case and said, yes, it was NOD. They didn't put it on the docket. I'm
Okay.
not sure of the reasoning, but it is my understanding that this outstanding warrant is the reason that Keon Clark was arrested, and that this is the only thing open.
All right. So we will hold on Keon Clark until Ms. Strong. If you also share that email with me, that would be very helpful. And Ms. Falk, hopefully you would have received it also.
Yes, Your Honor, and I've reached out to Mr. Walker to try to get some additional information so we can see what's going on, because you're absolutely right. It wouldn't have been an NOD on first appearance for a case from 2020 on a bench warrant.
Yeah, okay. All right, so while we are waiting on that, I have someone on a jail court iPhone. Who is that, please?
We have positions 30 and 31.
Judge, this is Charles Wilson. This is Mr. McLean's client. He is speaking with Mr. Beatty right now.
Whose client is she? Is he, excuse me?
This is Mr. McLean's client.
Okay, he's gonna have to speak with the
Yes,
individual then, and I'm sorry, what position number was that?
30 and 31. This is Charles Wilson.
Okay. Does Mr. McLean need to be in a breakout?
I don't believe so. I believe they've actually already spoken.
Is Mr. McLean ready?
He is speaking with Mr. Beatty right now.
All right, Mr. Charles Wilson, please hold, and as soon as your attorney is available, we'll address your case. Thank you.
I could make an announcement on position. Well, actually, no, I can't. He needs to be here.
Are you still talking to the folks in the courtroom too?
Yes, I just got back into the courtroom, but I do need
All
to
right.
figure out.
Let's go ahead and mute courtroom 2, and you can start your interviews.
And Your Honor, before we do that, I was able to go through some old notes and find some information on Keon Clark to share with the court and the PD's office.
Go ahead.
So it appears that Mr. Clark's was arrested on an obstruction of an officer where that case was NOD'd. His 2020 case, however, which is for battery, that case is an FTA, was never disposed of. So that case is still active. His new arrest on his obstruction was NOD'd. So this FTA is the thing that's holding him.
Understood. Okay, in that case, I do think that we are ready to move forward.
All right. Keon Clark, who is at the medical facility at the jail, your case number is 20 CR 002-534J, in which you are accused of battery from an August 6, 2019 incident. You do have an outstanding bench warrant for this particular case, and that is 23-001326 FTA. With regards to this matter, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. How are we proceeding, Ms. Vigiletti?
Mr. Clark is prepared to take a plea today, but did want to discuss the credit for time served based on their arrest date.
All right, so this will be a non-negotiated plea. So, Mr. Clark, I'll first hear from the prosecutor, then I'll hear from the defense and let you know my decision. I think we'll need to unmute medical pretty soon. All right, Ms. Falk?
Yes, Your Honor. We are asking for 30 days to serve credit for time served from, let's see, February 5th of 2024 when he was arrested on the FTA. Let me see if I can locate a previous arrest date for this offense. It looks like he also served from March 16th, 2020 to March 18th of 2020, which is an additional 3 days. So all in all, he would have served at this point 11 days. And we would ask the defense to stipulate to venue, factual basis, and identification. We'd also like to sound for Trajan Williams.
We do stipulate for the purposes of the plea.
Your initial statement, Ms. Falk, was credit for 9 days, and now we have additional 3 days, so that would be
Sorry,
12 days.
12. Yes, Your Honor.
Okay. And so it's just, and anything else in addition to the time served?
Stay away from Mr. Williams, but we are not placing, I mean, there's really no way to enforce the stay away. We're asking for just a straight time plea, given this case is 4 years old.
Okay. Miss Vigiletti, it appears that once he served the additional 2 days, that concludes his case.
Yes, Judge, I did just want to point out that Mr. Clark was arrested in DeKalb on February 2nd and asked the court to consider that in calculating time served today.
And the state's response was, do we have any proof that his arrest on February 2nd was solely based on this case?
And I don't, obviously, I've just met Keon Clark this morning. I don't have hard evidence, but that is what
he's gonna have to serve 2 days in jail.
Understood.
All right, so please unmute medical. Mr. Clark, you have to serve 2 more days at the Fulton County Jail, and this case will be closed. Would you like to accept this offer, or would you like to go to trial?
I do.
Okay. Please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah.
Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
Yes, for the purposes of the plea.
All right. Mr. Clark, have you consumed any medicine or alcohol?
No.
And has anybody forced you, induced you to take this plea offer?
No.
Are you satisfied with your attorney?
Yeah.
And has it been explained to you that if you plead guilty to this charge, that you would have to give up your right to a trial? You would not be able to confront your accuser, challenge the evidence brought against you, present your own defenses if you choose to do so, and give up your right to have the state carry its burden to prove the charge against you beyond a reasonable doubt.
Yeah.
Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of battery from August 2019?
Guilty.
Your sentence is to serve 30 days, credit for time served 12 days. You have 2 more days to serve at the jail. Please stay away from Trayon Williams. Thank you.
Thank you,
I apologize, Judge Law. Can you give me the plea one more time for Mr.
To serve 30 days, credit for time served 12 days. Balance suspended. That's it, time served. And stay away from Trayon Williams. All right, Ms. Vigiletti, if you would like to speak to those in the courtroom, is Mr. Michael McLean ready?
I believe he is.
What we got?
Looks
We have
like
anybody in
we
the
have
courtroom I can do?
position 30 and 31 here.
Yeah. Mr. McLean, how's your client proceeding on position 1, Beatty?
Undecided at the moment. I'm thinking about asking him about resetting a week as opposed to resetting to the, what we call the JJ.
We are either going to arraign the case and further notice it for trial, or we're going to take a plea. What would you, that's the option he has to decide. But in the meantime, you have a client at Jail Court iPhone, position 30 and 31?
Yes, Your Honor. Charles Wilson?
Yes.
Yes, that's I believe, consult my other sheets, that's a not guilty on a bond request.
Okay.
Let me-
Mr. Charles Wilson at Jail Court iPhone. You have 2 cases with us, 23 CR 001-211J, accused of battery, family violence. And the second case is 23 CR 001212J, also accused of battery, family violence from March 2nd, 2023. With respect to both cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. McLean has indicated that you plan to enter a not guilty plea. Shall we proceed in that manner? Mr. Wilson?
Yes, ma'am.
All right. Are you planning to enter a not guilty plea and have your case scheduled for trial?
Yes, ma'am.
Okay. Mr. McLean, do you waive a reading of the accusations in these 2 cases?
We do.
All right. Mr. Charles Wilson has indicated you've got 2 separate cases. Each case has 1 count of battery, family violence. These are misdemeanor charges, and upon your entry of a not guilty plea, the cases will be scheduled for trial. At the time of the trial, the prosecutor has the entire burden to prove these charges against you beyond a reasonable doubt. If the prosecution does prevail and overcomes your legal presumption of innocence, you could be convicted of one or both of these offenses. The penalty for such an offense would be up to 1 year in prison and or up to $1,000 fine. Given this information, how do you plead? Mr. Wilson, given this information, how do you plead?
Not guilty.
Could you please repeat? The Wi-Fi dropped just now.
I'm sorry, ma'am. Not guilty.
Was that not guilty?
Yes, ma'am. Not guilty.
All right. Both these cases have been arraigned and they're going to be further noticed for trial. Go ahead with your bond argument, Mr. McLean.
Your Honor, my client has understood from speaking to other lawyers that the alleged victim in the case has submitted an affidavit saying that the police report would be inaccurate. So we're not trying the case today, and I realize that. So, Your Honor, let me launch into his education. It's 11th grade. He, at the 11th grade level, he went to work doing janitorial work at the Airport Concourse D for 5 years. Then he got a forklift license. And at some point, he took a first offender on a case that was a felony case, and he wanted the court to know that went well. He successfully completed his first offender. He had an entering auto case at one point. Your Honor, he works for Caney and Lane. That's Kaney +signed or and Lane, Lane. And his brother still works there, and that's what kind of work is that again, Mr. Wilson?
We do all of Emory universities, university colleges, anything that deal with Emory. We do downtown hospitals. We blow with the sweeping crew. So whenever you go to the parking decks.
What they do is they blow everything off the parking decks and the parking lots of certain institutions that are large. So it's not a terribly large company, but his brother works there, and he knows from communication that he has a job waiting on him.
Okay.
He missed court, but not on purpose. His mother is 60-something years old. It's like 66, and she does have cancer. And he says that she definitely could use his help at home. Of course, he does have the brother. Your Honor, he has a 14-year-old son that he is missing and would like to be the family member out in freedom while waiting on this case to come up.
All right. Ms. Falk?
Yes, Your Honor. The state, I guess, is curious as to which of these cases the Ms. Davis is now saying did not occur and supposedly or purportedly wrote a statement to that effect, because we have the case on February 8th of 2023 where the defendant was alleged to have punched and pulled a ring on Ms. Davis's finger, which caused swelling and a laceration that was observed by the officers. We then have a case on March 2nd of 2023, where it was alleged that this defendant, with Miss Lakeisha Davis again as the victim, struck her and hit her in the face, which I believe was also observed by officers. And then we have a September incident for aggravated assault strangulation, which is in felony court, where he allegedly strangled Miss Lakeisha Davis. So I'm just curious as to which of these incidents did not occur from February to September of last year. The defendant had a $5,000 surety bond on both of our cases in state court. I cannot see the bond condition, but I have no belief in my mind there was a bond condition that did not include either no further violent contact with Miss Lakeisha Davis or flat out no further contact with her, either of which he would have violated by the strangulation case in September. And so for those reasons, as well as the fact that he didn't show up for court in May of 2023 for his plea and arraignment, which was less than 2 months after he bonded out on these cases, we would ask that no bond be given. I also have to state that no bond is currently on, unless that has changed, his aggravated strangulation cases in felony division.
Your Honor, I cannot satisfy the state's curiosity. I met him yesterday. I did not get a copy of the affidavit or affidavits if they're plural. I don't know. Magistrate court procedure in SAP has a certain timing to it. We're not trying the case today, as I mentioned, and it is what it is.
Yeah. Bond is set at $7,500 surety on each case. That's going to be a total of a $15,000 surety bond. No further contact with the victim. To stay 200 yards away from the victim. And Ms. Falk, if you could articulate the name, please.
It is Lakeisha Davis, Your Honor, Lakeshia. Davis, common spelling, and we would like to sound for her in case she is here in court.
Ms. Lakeisha Davis? All right. Please understand, Mr. Wilson, that this is an additional $15,000 bond that's now instituted in both cases. You are to stay 200 yards away from Ms. Davis. You're not to live with her. You're definitely not allowed to speak with her or communicate with her through mail, email, phone, social media, or even through a third party. If you share any children with her, that can only be through a third party transfer and not direct contact. Thank you.
Your Honor, my calendaring, my chicken scratching on the calendaring is perhaps not as clear to me as I wish it were. Is that 7.5 thousand on 31?
Each count, surety.
Okay, on each count. And there is position 30 and 31. Is one of those two not holding him in?
I'm putting 7,500 on each count.
Right. So that'll satisfy 30 and 31. I'll figure out how to word that. Thank you.
Okay. It's a modified bond for both cases.
What was the stay away address?
I do not have the stay away address, but let me try to locate it for you so that I can send that over.
Okay, thank you, Ms. Fall.
Thank you.
Okay, position 3031, arraigned and further notice for trial. Thank you.
Add on position 1 and 2, medical.
Oh, position 1 and 2. Okay, this is Gerald Masarira. And Mr. McLean, is that your client?
No, Your Honor, that's Ms. Vigiletti's.
Okay. Medical Miss Vigiletti is still speaking to her clients, and so we'll be with you shortly. Jail court iPhone, we're done with Mr. Wilson. Miss McLeod, you're going to go into a breakout. ACDC, who do we have there? Is that Purdue? Deputy Milton?
Be ready, Your Honor.
Is that Oriel Purdue?
Yes, Your Honor.
All right, we're going to put you in a breakout with Maureen McLeod.
Thank you, Your Honor.
Next champion will be for FCSO ACDC in a breakout with Miss McLeod. Thank you. All right. I have an individual who is on a phone, TCL T767W. Could you identify yourself? In which case are you here for? That's a lady sitting in a living room with a fan circulating above her. Yes, how we may help you? What's your name, please? Ma'am, can you hear me?
Are you talking to me?
Yes, I'm talking to you. The lady
Okay,
in the living room with the fan above her.
Well, I'm actually in our kitchen sitting at the table. Cynthia Clark. I'm Easton Clark's mother.
What's the defendant's name?
Easton Clark.
Okay, I think
he just called me and said they were bringing him over.
Please don't tell us anything that he's communicate with you. Okay. All right. So Easton Clark is represented by Mr. McLean. Mr. McLean?
Your Honor.
I'm so sorry. I think I have your client, Easton Clark, position 6.
Yes, Your Honor, that is simply a not guilty. Bond is moot. So that was one where I said I was going to write up a waiver and sign on his behalf with his permission.
All right. So Ms. Clark, that was the announcement from Easton Clark's attorney. He is submitting a waiver of arraignment, which means that he's waiving any having to appear in court today. He's entering a not guilty plea, and the case is going to be scheduled for trial. We do not have the trial dates right now.
Okay.
All right.
Thank you.
All right. You're free to go. Thank you.
Okay, thank you. How many times to go?
All right. And so Ms. Vigiletti, okay, I guess we're just waiting then for an attorney to be available. Okay. Mr. McLean, you're still talking on position 1 and 2?
I believe that's simply going to be a reset, Your Honor, and if that.
No, sir. No, sir.
No,
Call
I mean-
Mr. Beatty. That was his option, either
No,
to
no.
plead guilty or not guilty today. If he
Well,
wants to plead not guilty, which I think is where this is going, this case is going to be arraigned and further notice for trial.
No, my phrasing is just reset that to JJ, the jail jury.
All right, so are we arraigning his case? Or are you filing a waiver of arraignment?
We can file a waiver of arraignment, that's
All
fine.
right. Okay. Position number 1, Ms. Strong, please expect a waiver of arraignment. And this case is going to be further notice for trial. It's not going to go back on the SAP calendar. Its next appearance will be at the division judge's pre-trial calendar hearings.
It has a B, that'll be Judge Porter.
Okay, thank you. So let's see, Mr. McLean, we have the gentleman at medical. That's not your client, correct?
Correct.
Okay, that's Ms. Vigiletti. And she's still talking?
Yes, Judge, I'm prepared on position 9, Deshaun Fentress here in courtroom 2, or in medical is Gerald Masurita, and I could also move forward with him.
Can you go into a breakout with Gerald Massarira and then,
I've spoken with him already, so we're prepared.
okay,
Miss Vigilante, you might go ahead and do him because he got a grading appointment. He get ready to head out. So go ahead and do him now.
Yes, ma'am, let's do him first. Let me grab my paperwork.
okay. This is State versus Gerald Farah Massarira. And Mr. Massarira, you have 2 cases with us. The first one is 22 CR 006-560C, in which you're accused of criminal trespass from September 26, 2022. The second case is 12 CR 23 CR 11J, in which you're also accused of criminal trespass from January 1st, 2023. With regards to both cases, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Vigiletti. How are you proceeding, Ms. Vigiletti?
Yes, Judge. Mr. Masurita is prepared to take a plea today, but we did want to discuss the terms of the probation.
So are we taking a plea hearing right now, or? Okay, I guess I'll do that. Ms. Kim, what is the plea offer for Mr. Massarira?
Yes, Your Honor. There's a global recommendation for this case for 23 CR 000011J. The state's recommendation is going to be 12 months, serve 78 days, credit for time served 39 days, balance to be probated, no further contact with Maria Evans, and stay away from 1990 Lenox Road. And the state's recommendation for 22 CR 006560C will be 12 months of probation to run concurrent with the 23 CR case.
All right. Yes, Ms. Vigiletti?
Yes, Judge. We've spoken about Mr. Masurita many times. He does have cancer and he is homeless, and we are working together to try to help make his situation more tenable when he leaves the jail. But we were just wondering today if the court would be agreeable to a non-reporting status on probation, just because chemotherapy and securing housing is a significant burden already.
Does he have any other holds?
He does currently have another hold that should be resolved fairly shortly, an open felony case.
All right. His first visit has to be in person, and then after that, it will be non-reporting. Is that acceptable?
Mr. Masurita, you tell me.
Yes, ma'am.
All right. Please raise your right hand, Mr. Masurita. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Vigiletti, do we stipulate to the factual basis, venue, and ID for both cases?
We do, for the purposes of the plea.
Mr. Masurita, have you consumed any medicine or alcohol?
No, ma'am.
And has anybody forced or induced you to take a plea offer today?
No, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And are you entering this plea offer freely, willingly, and knowingly?
Yes, ma'am.
You understand that you would have to give up your constitutional right to a trial. You won't be able to confront your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass from September 26, 2022?
Guilty.
How do you plead to one count of criminal trespass from January 1st, 2023?
Guilty. Guilty.
With regards to the January 2023 case, your sentence is 12 months to serve 78 days, credit for time served 39 days. Once you're released, you will have to report to the probation office at 132 Mitchell Street on the first available weekday, which must be a Monday, Tuesday, or Thursday. And that would be your one and only visit with probation. After that, your probation will be non-reporting. At all times, you're to have no contact with Maria Evans and stay away from 1990 1990 Lenox Road in Atlanta, Georgia. Your sentence for the criminal trespass charge from September 2022 will run concurrent with the sentence I've just issued.
Yes, ma'am.
Thank you. All right, medical, that concludes the case there. Ms. McLeod, are you ready with Ms. Perdue's case?
Yes, Your Honor. This is going to be a negotiated plea.
All right. Ms. Perdue has two cases before us. Ms. Perdue, you've been advised of your right to remain silent, and your attorney is Ms. Maureen McLeod. Is Deputy Milton near you to unmute the screen? I'm going to get Deputy Milton a remote control next time. Okay.
Thank you.
Thank you, Deputy. All right, Ms. Perdue, you have two cases. They are 22 CR 002-531B, in which you've been charged with 3 counts of misdemeanor battery from March 28, 2020. Your second case is a bench warrant 24 FTA 86 for failure to appear in court. With respect to both cases, your counsel, Ms. McLeod, is going to represent you. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Kim, what's the plea offer for Ms. Perdue?
Yes, Your Honor, the state's recommendation for 22 CR 002531B for count 1, the recommendation is going to be 12 months, serve 82 days, credit for time served 41 days, balance to be placed on probation, 12 weeks of anger management, 40 hours of community service, no further contact with Latanja Watkins, that's LATONJUA, Watkins, common spelling, Zakia Hart, that's ZIKIYYAH, Hart, HART, Jasmine Watkins, JAZMINE, Watkins, common spelling, and India Hart, India, common spelling, Hart, HART. Stay away from 976 Fellowship Road, Fairborn, Georgia. No alcohols, drug, or weapons, and no firearms. Count 2 and count 3 each will run concurrent with count 1. And the state's recommendation for 24 FTA 000086 will be null pros as part of the plea agreement. The state would ask the defense to stipulate to ID, venue, and factual basis for purposes of the plea, and we would ask to sound for the victims at the end of this colloquy.
We stipulate.
All right.
Okay.
My goodness. Is Miss Latanja Watkins, Zakia Hart, Jasmine Watkins, or India Hart present? All right. Miss Perdue, if you decide to, well, first of all, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone forcing you to take this plea offer today?
No, ma'am.
Is there any reason for you to return to the Fellowship Road location?
No, ma'am.
Okay, so you don't have any belongings there and so forth?
No.
Okay. If you decide to plead guilty to these 3 counts of battery, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to confront your accuser, have the assistance of counsel to challenge the state's evidence, present your own arguments and defenses, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the 3 counts of battery?
Guilty.
Your sentence is 12 months to serve 82 days, credit for time served 41 days. You'll be placed on probation. If you have no other holds, you should be released within 24 hours. You have to report to probation next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While on probation, you will complete 12 anger management classes at an approved school. You would need to complete 40 hours of voluntary community service work, which can be done at any nonprofit agency that's not a church and not a school. You're also to stay 200 yards away and not communicate in any way, form, or manner with LaTanja Watkins, Jasmine Watkins, Zakia Hart, and India Hart. You are also to stay 200 yards away from 976 Fellowship Road in Fairburn, Georgia. That concludes your sentence. Thank you. I'm sorry.
Your Honor, yes, Your Honor, could I ask for the court to waive at least 3 months of her probation fees because she has been locked up for some time and she's unemployed?
Okay, I will waive probation fees for February, March, and April. She'll need to start paying probation fees from May 1st onwards.
And also, Your Honor, I would also like to ask if after she's successfully completed the anger management classes and the community service, her probation terminated.
I'm not going with termination, but Ms. Kim, any objection to non-reporting?
No, Your Honor, but objection to termination.
All right. If she's completed the anger management and the community service, and she's up to date with any and all probation fees, then her probation will be non-reporting.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
That concludes business before the court today. May I be excused?
Yes, Ms. McLeod. Thank you. Thank you, Deputy Milton. Thank you.
Thank you.
All right, we have Ms. Vigiletti. Are you still in the middle of interviews?
Yes, Judge, but I do see my client here on jail court's iPhone who did waive his presence at arraignment today. So we should maybe quickly.
All right.
He just got up.
Jail court iPhone?
I'm sorry, we just.
That's all right.
Now I'm not familiar with.
Okay. Deputy, who was the other individual who just walked away?
The first one, that was Michael Hubbard.
Okay, his appearance has been waived and Ms. Vigiletti has filed a waiver of arraignment. So his case is scheduled for trial. We won't need him.
Okay, I was just aware of that. Yeah. This next one is, what's your name? Mr. Lewis Wright, position number 32.
Right, is that Mr. McLean's client?
Yes, Judge.
Mr. McLean, have you had a chance to speak to Mr. Wright?
Yesterday, thankfully, that's a negotiated plea, Your Honor.
All right. Mr. Lewis Wright, my name is Judge Lal. Your case is 24 CR 341J, in which you were accused of misdemeanor possession of marijuana in violation of rules regarding pedestrian and roadway. You have a right to remain silent, and your attorney is Mr. Michael McLean. I understand this is not the case holding him at the jail. Would that be correct?
That is probably correct, Your Honor.
Okay. I have a note here. He got a $3,000 signature bond through the jail.
Right.
Okay. So are we still proceeding with the plea?
Yes, Your Honor. It's a very simple plea. It will be a recommendation from the state of time served and close the case, and he would like to get rid of the case and
okay.
Find him.
Mr. Wright, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right.
Nice meeting you.
Ms. Maldonado or Ms. Kim, is this case being transferred or are we, I'm just looking at the chat. Ms.
I believe they're
Maldonado.
referencing another case, Your Honor.
Oh, referencing another case. Okay, sorry, disregard that. Okay. Ms. Kim, what's the plea recommendation for Mr. Lewis Wright?
Yes, Your Honor, the state's recommendation is time served 33 days, and we would ask the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
We do.
All right. Mr. Wright, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And has it been explained to you that if you plead guilty to these two charges, that you give up your right to challenge this case in a court of law? There will be no trial. You will not be able to confront your accuser, and you will not have the right to have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of pedestrian roadway and misdemeanor possession of marijuana?
Yes.
Your sentence is 33 days, credit for time served, and 33 days, and that concludes the matter. Thank you.
Next, yeah, come on. Next, we have, Mr. What is this, position number 6? Mr. Easton Clark.
All right. Mr. Easton Clark, your attorney has filed a waiver of arraignment. In other words, has pled not guilty on your behalf, and your case is going to be scheduled for trial. We've already informed your mother.
When is it scheduled for?
I don't have the date yet.
Okay, thank you.
You're free to go.
Next, we have position number 3, Mr. Leon Bell.
Who's that?
Miss Vigiletti? Mr. McLean or Mr. Vigiletti, who represents Leon Bell? This was
That's me, Judge.
Okay. How would we like to proceed?
So Mr. Bell and I haven't spoken in a while, but last week we discussed a not guilty plea. Is that still correct, Mr. Bell?
Correct.
Okay, and Mr. Bell was supposed to be on last week's calendar, but then didn't get brought to court. And so he didn't waive his presence and arraignment. And so
Okay.
we're bringing it here today.
Do you waive a reading of the accusation? Ms. Vigiletti, do you waive a reading of the accusation?
We do.
All right. Mr. Leon Bell is 24 CR 395Y, accused of battery, simple battery against an officer and criminal trespass from January 17th, 2024. Mr. Bell, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Ms. Vigiletti is representing you for purposes of this proceeding. Upon your entry of a not guilty plea, the case is going to be scheduled for trial. At the time of the trial, the prosecutor would have the entire burden to prove the charges against you beyond a reasonable doubt. If the prosecution prevails and overcomes your legal presumption of innocence, you could be convicted of one or more of these charges. If so convicted, a possible sentence could be up to a year in prison and or up to $1,000 fine for each convicted offense. Given this information, how would you like to plead?
Innocent.
All right. This will be construed as a not guilty plea, and the case will be further noticed for trial. Thank you, Mr. Bell.
Thank you, Judge.
Great.
We have,
Come on.
we have a couple more, Officer Blunt, what's your name? Young? Court? Okay, we have, Mr. I'm sorry.
James Young?
Mr. James Young, yes, come on. Position number 33.
James Young, last position on the calendar needs to be interviewed.
Okay. Mr. McLean, would you happen to have access to a laptop so we can put you in a breakout?
What's his location, Your Honor?
Jail, court, iPhone. Where are you located, Deputy?
Well, I'm on 4 South. He got relocated to 4 South.
It's okay. It's okay. This is the person coming from mental health court, and so he has a separate attorney that's not here.
Yeah, I met you before.
Mr. McLean, would you be able to use Ms. Vigiletti's laptop and we can put you into a breakout?
I can do either that or run to the floor, Your Honor. It doesn't matter.
All right. Would the laptop suffice?
That'll be fine. Let's do that.
All right. Are you already logged? Are you already on Zoom?
I believe that
If you can unmute and start the video.
Your Honor, he's using a Vigiletti login.
Yeah, understand.
There we go.
Okay. Miss Champion, if you could place Mr. McLean, who is on Olivia Vigiletti laptop, and jail court iPhone, we'll give you a breakout session as well.
Your Honor, in front of you now is going to be position number 3 on the add-on calendar. Mr. Seaver.
Judge, I believe another attorney was here this morning and made an announcement about Mr. Siebert.
That is correct, Your Honor. Ms. Melnick made the announcement that that would be reset to misdemeanor MMHC on Thursday. Excuse me.
Yes. Mr. Siebert, your case will be addressed on Thursday at 11 a.m. All right, that's all I have. That's the only information I have on your case.
All right, thank you very much.
Thank you. Mhm.
You welcome.
We can go to benches.
All right, Ms. Vigiletti, back to interviews.
We can go to position number 9.
Deshaun Fentress.
This is State versus Deshaun Fentress, 23 CR 1922F, position number 9 on the SAP calendar. Mr. Fentress was accused of reckless conduct and failure to have the necessary Fulton County license.
Okay, so since she froze, what number are we on?
Ms. Falk, I believe you're muted.
Position number 9, Deshaun
Okay.
Fentress.
Thank you.
And I thought I was frozen for a second, but I realized it's the judge that's frozen. PD Vigiletti, real quick, what is the announcement on this one?
We'd like to discuss the possibility of a non-negotiated plea. It looks like the offer is 2 years of probation, and Mr. Fentress has 0 criminal history, and he did surrender the dog to the shelter after this incident.
Okay, then I will handle this instead of ASG Kim.
I'm so sorry. I think I don't know what happened, but I'm not going to go into that, but I'm back. And as I was telling Mr. Fentress, he has a constitutional right to remain silent, and his attorney is Ms. Vigiletti. How are we proceeding?
Judge, we'd like to discuss the possibility of a non-negotiated plea this morning.
All right. That case, Ms. Falk, what's the plea offer?
Your Honor, the state's recommendation on this case is on count 1, the reckless conduct, 12 months probated. Count 2, 12 months probation consecutive. We are asking the restitution remain open for 30 days for information from Mr. Raul Perez. This incident happened on May 8th, 2022. Mr. Perez was in a hotel on Virginia Avenue in Fulton County. The defendant was in the hotel with Max, his male blonde Siberian husky mix. Max bit Mr. Perez's arm and tore his shirt. The defendant did not have a Fulton County license for Max, and when was questioned by the officer, the animal control officer, he was unsure whether Max was current on his vaccinations. Mr. Perez, as a result of this incident, required medical treatment, lost his job as a result of this incident because he was unable to cover his shifts. And in speaking to Mr. Perez, he stated he was out of work for 3 months. And because Mr. Fentress was unable to provide any documentation as to the shots or vaccinations, Mr. Perez had to get treatment for his rabies, for possible rabies. So this was a very bad situation for him. And that is the reason we are asking for that 24 months so that Mr. Perez can be fully compensated with any restitution documents that he's able to provide for this to the state.
Are you any objection to non-reporting probation while restitution is resolved?
No objection, and we would like to sound for Mr. Raul Perez.
Okay. Mr. Raul Perez, if you're present, please unmute and start your video. All right. Ms. Vigiletti, what's the defense's position?
Yes, Judge. Mr. Fentress has absolutely no criminal history. He did relinquish the dog to the shelter after this incident. Takes full responsibility for not having the license for the dog. He does work full-time as a security guard. He is just trying to get home in time to keep his job, has been working hard to maintain his job, even though he's been in here for almost 3 weeks. He does have significant community in Georgia. Like I said, he's never been in trouble before, hasn't been in trouble since. So we would just ask for a time served plea, but in the alternative, a non-reporting status on the probation.
All right. I'll do a 12-month concurrent probation. Miss Falk, the alleged victim has 2 years from the incident date to file a civil claim for injuries and personal injuries. So he has till May 8th, 2024 to claim any restitution as well. So please make sure that your alleged victim does respond. But it will be 12 months concurrent probation, and it will be for the first visit he'll have to do in person, and then after that it will be non-reporting for the remainder of the 12 months. And no contact with Raul Perez, with the exception of addressing restitution or a civil claim for damages. Is that something your client would like to accept?
Yes, Judge. And I did just want to put on the record, since there might be a civil suit, that Mr. Fentress states that Raul Perez was quite drunk and out of control at the hotel. So I do just want to state that for the record in case there's further proceedings.
Well, I'm sure they'll go to mitigation, but is he pleading to reckless conduct and not having?
Yeah, no, I'm sorry, Judge. It doesn't impact the plea. I just forgot to state it earlier.
All right. Okay, Mr. Fentress, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
All right. Mr. Fentress, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings?
Yes, Your Honor.
Are you satisfied with your attorney?
I am.
And is anyone forcing you to plead guilty to these charges?
No, Your Honor.
If you do so, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity of retaining counsel to go into a court to challenge the evidence presented against you, to confront your accuser, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of reckless conduct and 1 count of not having Fulton County license tags?
Plead guilty.
Your sentence is going to be 12 months. It's going to be a concurrent sentence as a 12-month probation. You report to probation for the first visit, and that report will be next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. After that, your probation will be non-reporting. This case will remain open for 30 days for the state to schedule a hearing in order to address restitution, which will be the amount that you owe to the victim, Mr. Raul Perez, as a result of this incident. And you will, then that concludes the case. Thank you.
Thank you.
I apologize. What is his plea 12 months to? What?
It's a 12 months probation, and it's concurrent for both sentences. He reports the first visit, and after that is a non-reporting probation. Stay away from Raul Perez. Restitution open 30 days. We good, Ms. Strong?
Thank you, Judge.
Thank you.
All right. Ms. Vigilante, you still talking to your clients?
Yes, I need to finish up a discussion with probation position 1, Willie Moore.
Okay. We have a domestic violence bench warrant matter. For Brianna Floyd James. I think Brianna Floyd appeared on screen. Brianna Floyd James. All right, Mr. Brianna Floyd James.
Yes, I'm here.
All right, get out of bed and go to a table and chair.
It's loud in there. I can stand in the bathroom.
Why is it loud in the, are you in some kind of apartment?
Yes, my baby's in the other room.
I see, okay. Miss Brianna Floyd James, you were accused of 2 counts of battery family violence from October 1st, 2022 in case number 23 CR 5669H. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. And who's your attorney?
I don't have an attorney.
All right. Have you spoken to a public defense attorney?
Your Honor.
I'm sorry?
She has.
All right. Have you spoken to you, Mr. McLean?
Yes, on the phone.
All right. So Ms. Floyd is here on a bench warrant for failure to appear in court, and she submitted a request to set aside the bench warrant. Mr. McLean, anything to add?
Your Honor, these days I found it was a couple of weeks ago, I found it quite easy to find her. You Google it, whatever happened to cause her to miss court won't be happening again. She actually came, Your Honor, when she was on the jail a week or 2 ago. She actually came to the jail building here at 901 Rice Street because I had told her on the phone, I said, look, it's, all of a sudden there's been this computer attack. We don't know what's happening. You want to show yourself to be sharp and on top of things. So just in case you can't Zoom on, can you be real close to the jail courtroom or just walk into the jail courtroom as a member of the public, because we have a public section. And she came here and she talked to one deputy and they said, no, you can't be in there. You're not incarcerated, because she told him she was a defendant. She said, well, you're not incarcerated. You can't go in that courtroom. So there was some misunderstanding, but it shows her effort. It just shows her effort and her willingness to show up when and where. I've had clients who showed up at the courtroom and got arrested before. So she is on top of it, Your Honor, and will promise that she will not miss court again.
Ms. Paul, any comment?
No, Your Honor, I'm not sure what the explanation is, because I didn't hear one for why she missed court on this occasion. It looks like she missed court on November 30th of 2023, which I believe was, and I just switched from that screen, a plea and arraignment, I believe. And so she also has a second case that I'm trying to see, but it's taking a bit of time to see what was going on with that case.
All right. Anything else, Ms. Paul?
Other than the state would ask the bench warrant not be lifted, given that there has been no reasonable explanation given for why she did not appear for court when called.
Mr. McLean?
Oftentimes, Your Honor, it's just a matter of a person not realizing they need to update their address with the clerk. Is that what happened, Ms. Floyd?
Yes.
All right.
So she admits her fault, but I think has made up for it by showing her initiative.
I'm going to set aside the bench warrant by this Friday before 5 p.m. I don't think we have a public holiday this week. I think we have one next week, but not this week. But this week, by before 5 p.m., February 16th, Miss Floyd James, you will come down to the courthouse in person at 160 Prior Street to the clerk's office. Use your case number and update your mailing address, your phone number, and your email. And you're going to do that in person. Do you understand?
Yes, ma'am.
And anytime you change either one of that, your mailing address, your phone number, email, you have to update the court just like that.
Okay.
And also, we will give you a court date on this case eventually, and you'll need to appear in person.
You want
Okay.
to
Judge Law, I'm sorry. It looks like she already did this information. If
Okay.
this is correct, when she came in to be placed on this calendar.
I see. Okay, good. So anytime you change that, you will need to come back to court and amend that. And if you fail to appear, it becomes another failure to appear on your criminal record. And if things don't go well, these kind of things come back and bite you in the future. All right, thank you. Mr. McLean, you will do the honors?
I will. Thank you.
All right, thank you. All right, while we are waiting for the other cases to be addressed, anyone has any update on our probation calendar?
Your Honor, I represent Mr. Orlando Reed on the calendar, and I will be ready in just a moment with him. He's simply going to be recommended to be continued.
Is that the gentleman on the jail court iPhone?
He is behind me, Your Honor, on one of these pews.
Oh, I see. What about the gentleman on the jail court iPhone? Were you speaking with him?
Let's see, is that Mr. I was just speaking with James Young. Is that Mr. James Young? I probably had my head down, didn't memorize his face, Your Honor, but he's ready.
Okay.
That's a negotiated,
just,
negotiated plea.
Okay, just a couple of things. Will the host please stop the video on Olivia Vigiletti's laptop? It's just, I'm seeing two McLeans right now. So, okay, thank you. All right, thank you. And repeat the name of the client at jail court iPhone.
James Young, position 33.
Thank you, thank you.
We had announced probable plea and we turned out to be correct.
Okay. This is State versus James Young, 21 CR 004-804Y. Mr. Young has been accused from a September 3rd, 2021 incident. The charges are maintaining a disorderly house, giving false information to a law enforcement officer, and willful obstruction of an officer. Mr. Young, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. This is going to be a plea, so could you please raise your right hand? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Kim, what's the recommendation?
Your Honor, the recommendation for this case would be time served, I believe 15 days, and the state would ask the defense to stipulate to ID, venue, and factual basis of purposes of this plea.
We do.
All right. Mr. Young, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Are you satisfied with your attorney?
Yes, ma'am.
And is anyone, excuse me, are you being forced or induced to take this plea offer today?
No, Your Honor.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to challenge them in a court of law. You will not have the opportunity of going back to face your accuser, challenge the evidence brought against you, and have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of maintaining a disorderly house, giving false information to an officer, and willful obstruction of an officer?
Guilty.
Your sentence is to serve 15 days, credit for time served 15 days. That concludes the case. Thank you.
All right. Have a good one, Your Honor.
You too. Thank you.
Next, we have position number 15.
I'm
Mr.
sorry.
Eric Hinton.
If I could just interrupt very briefly, Judge. Positions 10 and 11, Cartez Gibbs is supposed to be represented by Ms. McLeod. And if I remember correctly, Ms. McLeod was excused earlier.
Yes, I didn't know that she was, I don't have the attorney representation.
Yeah.
So, Ms. Falk or Ms. Kim, what is the, is there additional jail time in an offer for Mr. Gibbs?
For Mr. Gibbs, Your Honor, and my understanding that is position 10 and 11. Is that
Yes,
correct?
correct.
So we are asking for 45 days. He has served 30 so far. So yes, we would need to, this would terminate his case.
All right, I'm going to reset it to next Tuesday, which will be February 20th.
Sorry, so there is no additional jail time, right?
There is, well, It is,
Yeah, we asked for 45 days.
Total, so would that be 23 days here in the jail?
That would be, yes, 23 days in the
So
jail.
this would conclude his case, and he would be released in 24 to 48 hours.
so I'm a little confused. It was to serve 45 days and he has served 23 days?
He was arrested January 19th, 2024. Hold on, let me go to the calculator and see what that would be. January 19th.
So in that case, I'll reset him to this Thursday, which will be the 15th.
Okay, state will be ready.
Okay. Miss Strong or Miss Champion, can we just send an email out to Miss McLeod? That
Yes,
she missed one of our clients on today's SAP, but we'll address it on February 15th. Position 10 and 11. Okay, and then Ms. Vigilante, do you have any other announcements?
I do, yes, probation position 1. I'm just requesting a reset to this Thursday. Mr. Moore does have proof that he has completed some of the terms, but I'm gonna have to make some calls to get that proof.
Okay, are we having a probation calendar on Thursday, Miss Strong?
Let me, give me a second. Let me confirm.
Okay. Meantime, I have
Yes.
position.
I'm sorry, Judge Law. We do have a calendar on Thursday.
Okay, so we're gonna reset that probation matter to this Thursday.
That would be great. Thank you, Judge.
And this was, which position?
This is probation position 1, Willie Moore.
Okay, thank you.
Thank you.
Jail court iPhone, we have position 15, which is Eric Hinton.
Yes, Judge, this is one of the cases where Mr. Hinton's intake was not complete yesterday, so we didn't get to speak with him, but I am happy to go do so right now.
Okay. Jail court iPhone, you're gonna be in a breakout with Miss Olivia Vigilante. So Miss Vigilante, as soon as you're on the laptop.
Yep, I'm here.
Okay. I think the host needs to send you a prompt to start video unless we switched it up. Thank you.
Your Honor, in the courtroom, we have Orlando Reed ready for a probation matter.
Okay. And that was position Orlando 3. Okay.
Right, I believe it was 3.
Okay. Orlando Reed. My probation officer, I think it was Officer Brooks. I think.
Yes, Your Honor, I'm here. My apologies. How can I help you?
I think we got a probation case, lo and behold. Okay.
Okay,
Right.
I'm ready.
Please raise your right hand, Miss Officer Brooks. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. We have position 3 on our probation calendar, State versus Orlando Reed, accused of theft by taking from, not accused, convicted of theft by taking. And this is a case in which there's been a warrant for a probation violation. Mr. Reed, we're going to first hear the reasons why the state's seeking a revocation of your sentence, and then your attorney will explain otherwise. Please remember that you have the right to remain silent. Anything you say in open court, your statements can and will be used against you. Officer Brooks?
Yes, thank you, Your Honor. The probationer failed to appear for a revocation hearing on July the 11th, and the reason we requested that hearing was because he did not complete his conditions of probation, which was an anti-theft course. And we are asking that he be allowed to remain on probation, but we do want that course completed within 30 days.
How many more days does he have left?
1 second, Your Honor, my apologies. Give me just 1 second and I'll tell you.
No problem, no problem.
He has 289 days remaining on probation, Your Honor.
All right, thank you. Mr. McLean, is there a problem completing the anti-theft class?
No, Your Honor, there will not be. He is bound and determined with enthusiasm to, if Your Honor can give him that chance to get out of the jail and get these things done, he will not break his promise to complete.
Mr. Reed, I will accept the state's recommendation. We're going to continue you on probation. You have to report to, today's Tuesday, you'll report to probation on Thursday this week before 3 p.m. Do you understand?
Yes, Your Honor.
And that's at 132 Mitchell Street. So don't forget to report to probation this week. And then you have 30 days to complete this anti-theft class, which means that by your second probation visit, you must bring your certificate showing that you've completed the class. Once you've submitted the certificate and your probation officer is satisfied, your probation will be non-reporting. Do you understand?
Yes, Your Honor.
If you don't complete the class by your second probation visit, probation is authorized to issue another probation warrant and have your sentence revoked in its entirety, which means that you spend the remainder of 250 days. No, 240 days in the jail. Do you understand, sir?
Yes, Your Honor.
All right. No more. I'm not going to do this again. Okay.
Yes, Your Honor.
All right. You have 30 days to complete the class and your probation's non-reporting. Otherwise, just take a straight trip to the jail. Thank you.
Thank you. Take that piece of paper.
What do you want me to say that, right here?
Yes.
All right, Officer Brooks, I think position 1, Willie Moore, is going to be reset to February 15th.
You said February the 15th?
Yeah, this Thursday.
Okay, Your Honor.
So the only other 2 probation matters is position 2, Terrence Wilburn, and position 4, DeMontre Kendall.
Yes, Your Honor.
Okay. Okay, iPhone, if you would like to ask for information, you need to unmute and start your video. Person who is on iPhone, you have to unmute and start your video. Joanna Mobley.
Ma'am.
All right. Could you please put your phone to its direct? Are you recording this proceeding?
No, ma'am.
All right. And why are you here?
Oh, she just told me I can get off. I was chatting with them. I was here on regards of Cortez Gibbs, but she said that it got reset.
Okay, all right, you're free to go. Thank you.
Thanks.
All right, I think we are in recess. It is 11:25. We're going to take a 5-minute recess and resume at 11:30. I think Ms. Vigiletti is still talking to some clients. Ms. Champion, we can pause the recording for 5 minutes. Okay. Courtroom 2, is anyone ready to address the cases? And jail court iPhone, who do we have, please?
We have position number 15, Mr. Eric Hinton.
Okay. Ms. Vigiletti?
Yes, Judge, Mr. Hinton would like to accept the plea recommended by the state, so we just ask that you accept the plea as recommended this morning.
Thank you. Mr. Eric Hinton, your case is 20 CR 3804D, in which you were accused of battery, family violence, and cruelty in the 3rd degree. You have a right to remain silent. Anything you say in open court about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Vigiletti. May I place you under oath for purposes of the plea?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Kim, what's the recommendation?
Yes, Your Honor, the state's recommendation for for both cases, I believe, is 12 months, serve 30 days, credit for time served 15 days, complete a family violence intervention program, and no further contact with Brittany Hurst. Brittany's common spelling, Hurst, is Hurst. State would ask to sound for the victim at the end of the colloquy and ask the defense to stipulate to ID, venue, and factual basis for purposes of this plea.
All right. Brittany Hurst. All right, Ms. Vigiletti?
We do stipulate for the purposes of the plea. And just because Mr. Hinton, I didn't say this out loud to you earlier, when they say serve 30 days, credit for time served 15, that's the time served plea we talked about, okay? Because this jail gives double credit.
Okay. Okay.
So you don't have additional jail time for this case. Is that your understanding?
Yes, ma'am.
All right. Ms. Hinton, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And are you satisfied with your attorney?
Yes, ma'am.
Has it been explained to you that if you decide to plead guilty, that you would have to give up your constitutional right to a trial in front of a judge or a jury? You will not be able to have the assistance of counsel to go back to court and confront your accuser, challenge the evidence brought against you, present any defenses or arguments on your behalf, as well as have the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And do you understand that by pleading guilty to battery, family violence, that in the future, if you're ever arrested for a similar offense, it would automatically be a felony charge?
Yes, ma'am.
Are you still willing to move forward with this plea willingly, knowing and voluntarily?
Yes,
Yes.
ma'am.
Okay. How do you plead to one count of battery, family violence, and cruelty in the 3rd degree?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days. You don't have additional jail time, but you would have to report to probation next Tuesday before 3 p.m. at 132 Mitchell Street in downtown Atlanta. While you're on probation, you're to enroll and complete a domestic violence intervention program. You must enroll in that program within 60 days of being released. Do you understand?
Yes, ma'am.
All right. If you don't enroll within 60 days, probation is authorized to issue a probation warrant for your arrest.
Yes, ma'am.
At all times while you're on probation, you have to have no contact with Brittany Hurst. You have to stay 200 yards away from her and not communicate with her in any way, form, or manner, including mail, email, phone, third parties, and social media. Do you share any children with her?
I'm sorry, I couldn't hear you, ma'am.
Do you share any children with her?
No, ma'am.
All right, then that concludes the sentence. Thank you.
Thank you, miss.
Thank you, Judge.
What's up?
Yes, we are concluded with Mr. Hinton. Thank you, officer.
Okay, yes. Next we have positions number 28 and 29, Denzel Williams.
Would that be Mr. McLean's?
And Mr. McLean, Mr. Williams was another person who was lost yesterday, so Mr. McLean has not yet spoken with him. I'm giving Mr. McLean my laptop right now, I will say the court has made it so that I can't turn my video on. If it's possible, whoever's hosting the Zoom.
Yes, that was our fault. Actually, that was my fault. But Ms. Champion, could you send Ms. Vigilante's laptop a start video prompt? There we go. Lovely. See Mr. McLean's lovely face there. Okay. All right, Mr. McLean, you are going to go into a breakout room. Jail court iPhone. You will see a message to go into a breakout room. And Ms. Vigilante, are we still conducting interviews for one?
Judge, I have 3 more clients on my calendar. I can make an announcement about one of them.
Go ahead.
William Pascal. And of course, I just handed Mr. McLean my laptop, so I'm not sure what he has 2 cases. I'm not sure what position numbers those are.
18 and 19?
18
Yes.
and 19. It's my understanding he is still at Grady Hospital, which has been the case for a couple of weeks now.
Position 18 and 19 are reset to February 20th, excuse me,
Okay.
Tuesday.
The other 2 clients, I'm sorry, I just handed Mr. McLean my notes that are.
I know, I'm so sorry.
That's okay. My final 2 clients are folks that we have not been able to locate, and they're not here today, so I'm not quite sure.
Which ones are the 2? Godinez, okay, that's with a G.
Yes. What's the position number?
That is position 13, Mikael Godinez.
Yes.
Okay.
And then also position number 12, Wayland Gibson.
Right. Is Officer Norris in the courtroom with you?
This is Officer St. Seren.
I'm sorry?
Is Officer St. Seren in?
Oh, yes, Officer Sansorin. Do we have an update on those 2?
No, not at the moment.
Okay. Well, we have a couple more cases to go through. Have we addressed everyone else seated in the gallery pew?
Yes, Judge.
Okay. We still have 2 probation cases that have not been addressed. Terrence Wilburn, position number 2. And DeMontre Kendall, position number 4. Any updates, officer?
No, Your Honor, are they not present?
So those are both Mr. McLean's clients, and both of those clients were supposed to be located in 2 South yesterday, and every single client in 2 South yesterday is mysteriously lost. So Mr. McLean has not spoken with them, and we do not know where they are.
Okay. So those 2 probation cases and Miss Vigilante's 2 cases on the SAP calendar. Okay. Then on my add-on. Okay. On my add-on, I'm looking on Taekwon Thurman.
I'm sorry, I actually am just hearing from Officer St. Seren that Wilburn on the probation calendar is not in custody. I'm a bit confused about that.
Okay. And what about, okay. Miss Vigilante, do these names ring a bell? Taekwon Thurman.
He is another gentleman that we're having a hard time finding.
Okay.
He's been reset a couple, I think this will be his.
He's on 4 South. I told him, Mr. saying he's on 4 South 5 and 6.
Okay.
We'll see.
And Stephen Williams.
Stephen Williams, that is Mr. McLean's case. I'm not sure.
Okay. All right, that's position 7. Okay. All right, not a problem. We're just having some little bit of little bit more effort to be put in because of all these IT issues that we have. So, let me see. I'm going to be waiting on Mr. McLean, and then we will get a final update when we go through the calendar in a few moments. Okay?
Okay, thank you.
All right, thank you.
So I would like.
Okay. Come on.
Thank you.
We'll see you tomorrow. On the right side. You can start right here. How's it going?
Ms. Vigiletti, could you just check on Mr. McLean's breakout? Because it'll be time soon. Thank you. All right, Mr. McLean? Where are we right now? Oh, I'm sorry, it's the quorum 2 is muted.
Your Honor, Mr. Williams' first name is misspelled like I suspected. It really is EL.
Okay. This is Denzel Williams with an, how do you spell it?
Denzel.
Z-E-L.
Just,
Okay,
just like
so
the actor.
do we have the date of birth correct? August 4th, 2000?
Let me turn to my other sheet, Your Honor. Let's see, Williams, I guess. Where did I write his date of birth? Your Honor, we could chat his date of birth. I could get it from. He is the person that's aware of these cases, and I've got his booking number.
Yeah, we'll make a note on our files right now in writing that Denzel's D-E-N-Z-A-L is also known as D-E-N-Z-E-L. Okay.
Right, the birth certificate knows him the correct way.
All right. And how would we like to proceed in his 2 cases?
This is a negotiated plea, Your Honor.
Okay. We're going to pause the YouTube, please.